And I've long thought that if our social consensus, or at least if the consensus of those who are likely to be appointed to the bench, is that religion is a bad thing, then we're going to get jurisprudence that tries to limit its public influence and significance. Just a just like I think our pornography jurisprudence changed when at least elites began to think, well, it's not such a bad thing.
Yeah, I think there's a lot of truth to that. The Everson case, my friend Don Drakeman, who's associated with Notre Dame and Princeton University, wrote a terrific book on the Everson opinion. And what he found is that there's a lot of anti-Catholicism that animated the justices. The justices at the time, this is sort of the older Protestant establishment, didn't want public money or state money going to Catholic schools. And that's what they were concerned about. And you could say that was a dominant elite culture opinion of the time. This is before John F. Kennedy became president. Could Catholics really be a part of America? Even if Catholics are going to be part of America, we don't want government funding Catholic schools. And you could say the original wall of separation is tinged with anti-Catholicism. Take Jody Bottom's book on the development. The original Protestants who were anti-Catholic, now they're post-Protestants and they're anti-religious.
Right.
Because I think that development in the court's jurisprudence.
Yeah, I mean, there's always, the cases that are, and the issues before the court that are always culturally controversial they involve, decisions that press, on the margins or press on the limits of our constitutional system. And like I said, if there's I think that's Paul Blanchard's book, warning about the threat that Catholicism posed to American democracy. I think that was published in the late 1940s. That was a big bestseller. So if you think as a judge, you're a Supreme Court justice, that Catholicism poses a threat to the body politic, and this case comes before you, and you'd be very tempted to adjust pretty significantly, the boundaries of our religious liberty jurisprudence, it seems to me, our First Amendment jurisprudence.
Yeah, and the way they do that is the justices issue these vague and broad standards, a wall of separation. Well, what does that mean? Well, in truth, it means whatever the justices or later courts want to say it means. But you can always use it as a hammer against religion or those forms of religion that you don't like.
You, in your piece, you digress. You point out that, well, whatever the Constitution whatever people had in mind when they voted for the First Amendment, it was clear that, in the actual practice in the states, it's not at all what we think it is now. And you give the example of South Carolina, which is a fascinating example. I mean, Massachusetts and Connecticut and other places had establishment, but here you have a state that actually erects a certain kind of religious establishment after the fact, rather than simply continuing with one they had already. Am I correct in that?
Yeah, well, I'm going to push back a little bit on one of your factual statements. So what you say is what everyone says. So everyone says there are 6 or 7 states that had an establishment of religion at the time of the founding. And probably 10 years ago, I just sat down and said, okay, well, what were the 6 states? I just wanted to document this. So I went through and I read the state constitutions of the time. And much to my confusion, there was only one state that said we have an establishment of religion. That's the 1778 South Carolina state constitution. So I was trying to figure out, well, why does everyone say 6 or 7 states had establishments? It's because following the court's modern jurisprudence, the funding of religion, government funding of religion, is considered to be an establishment. And arguably 6 or 7 states funded religion in various forms. And therefore, we say now that 6 or 7 states had an establishment of religion.
So your point is that they did not consider that establishment.
It was very much disputed on what is and what is not an establishment. Some people said funding of religion, James Madison said funding of religion is an establishment. So he might agree that Massachusetts in 78 established a religion. But other people would say no. And one of the easiest ways to determine what is an establishment is just to say what states actually said we have an establishment.
Right.
By that definition, only one. And it seems that one state, if we want to understand what an establishment was in its most essential forms, we should turn to that state. That's not Virginia and that's not Massachusetts. That's actually South Carolina.
And they established very minimal creedal standards for being able to incorporate as a church. And then one of the benefits of that incorporation is that these churches then assume taxing power over their members.
Yeah,
Am I
that's
getting that right?
exactly right. So if you look at what the state of South Carolina did in 1778 when it established a religion, it extended certain privileges to established churches, and then it also extended certain regulations. So to be incorporated, there are no general incorporation. This seems very technical, but it's pretty important. There are no general incorporation statutes at the time.
Yes, right.
So if
You had to have active legislature
you,
in order to incorporate to collect tolls for the bridge that you built.
Exactly. So if your church wants to own property, have legal standing, be able to protect its rights to sue, it has to be incorporated. Only established churches could get incorporated. That's a huge legal privilege. When those churches were incorporated, they had to meet certain requirements. They had to subscribe to certain articles of faith, which were prescribed in the state constitution. So
Yeah,
this
I
really,
looked at
Mhm.
yeah, I looked at that, and that's fascinating, right? So basically, you could not be a Unitarian and or a Socinian or whatever and get this incorporation. And this is in contrast to Massachusetts and the whole crisis in Massachusetts over um, state state funding of religion turned on the fact that there were no doctrinal standards,
That's right.
and
That's
it was a crisis when the people who paid taxes in the township got to vote on the next pastor, not the people who went to church, because you pay the taxes, you should have a say in who the and then they would vote for Unitarian ministers, but the church members wanted traditional Congregationalist Trinitarian.
that's
So
right.
yeah,
One,
so
one, one other element of an establishment is when the state prescribes how ministers are to be selected, right? So this is you couldn't be Catholic in either of these states and have legal recognition, at least in terms of establishment provisions, because in South Carolina, in the Constitution, it said ministers must be selected by the people, right? Not appointed by bishops or other church authorities. And the same was true in Massachusetts. That's why some people say, well, Massachusetts had elements of an establishment because the state constitutions themselves prescribed how ministers were selected.
right. Yeah, I think Mark DeWitt Howe's book on, I think it's called The Wilderness and the Garden, as he documents, it was religious leaders that uh, ultimately led the charge against these forms of establishment. And it turned on these effectively. The state of South Carolina was dictating an ecclesiology, a Congregationalist ecclesiology, and then whether you're a Presbyterian or a Episcopalian or what have you, this didn't float. So
That's right. You could say, I mean, and I use slightly different language in my new book, but you could say establishments are state regulation of religious institutions as such. This is how you must select your ministers. These are the tenets of faith you must prescribe. And then extending special state privileges to institutional churches, right? We will buy you property or we will delegate our taxing authority to you, the state's authority.